In this video we're going to examine a previously unseen transcript from the court case of Lucy Letby, in which Ben Myers essentially demolishes Dewi Evans and his performance during the trial. This took place on Monday the 9th of January 2023. Proceedings on that day began at 10:53 a.m. with the presiding judge, Lord Justice Goss, making some comments about the nature of this being a public trial. Now, this is an extremely long document, so I'm going to skip over the first few pages, even though there's some interesting interaction between Myers, Goss and Johnson. So Ben Myers is the defence barrister, Judge Goss is the presiding judge, and Nick Johnson was the prosecuting barrister. I may cover that at some point in the future, but I want to get straight into Ben Myers essentially explaining to the court why the lead prosecution witness, Dr Dewi Evans, should be excluded from the process. So this application and the presentation of Ben Myers begins here. This is on page 8 of the document, and it concludes here, and this is on page 111 of the document. So I'm going to go over this in its totality over what will probably be at least 2 videos, and it could likely be more than 2 videos, but I do want to cover this as a whole so that we can see exactly what was said and how accurate this was. But I'm going to begin the process in this video. So I'll begin reading Ben Myers' words, and then if I feel there's a need to clarify or corroborate anything that's being said, then I'll do that. This is an application, my lord, that is twofold. The principal application is to exclude evidence from Dewi Evans, who is the consultant paediatrician relied upon by the prosecution as one of the experts in this case. Secondary to that, in the event of that application not succeeding, it is an application to introduce evidence of bad character or otherwise introduce the evidence that comes from the decision of Lord Justice Jackson. The first part of the application and the principal application we make is on the basis we say that Dr Evans has failed to act with the independence, impartiality and objectivity required of a witness whose evidence is admitted on the basis of their expert status. So we say it fails to meet the necessary standard to be admissible. So I think just 2 quick reflections there. If people don't know, Lord Justice Jackson wrote to the trial judge, James Goss, in the Lucy Letby case to state that Evans had submitted a report in a previous case and that he deemed it to be worthless and that he'd made no effort to give a balanced opinion. And that feeds into the second point, which is it's pretty much the worst thing you can do as an expert witness to not be objective and to not be impartial. And obviously the 2 things very obviously tie together. Alternatively, but still on the question of admissibility, we say that considered in total, the effect of that evidence has or would have such an adverse effect on the fairness of the proceedings that it should not be admitted. We put that at our paragraph 4 at the start of our submission, and we rely upon section 78 of the Police and Criminal Evidence Act. So the section referred to there by Ben Myers is on the screen now: exclusion of unfair evidence. In any proceedings, the court may refuse to allow evidence on which the prosecution proposes to rely to be given if it appears to the court that, having regard to all the circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would have such an adverse effect on the fairness of the proceedings that the court ought not to admit it. And that's really essentially it. The second thing is just an issue of jurisprudence. So Ben Myers continues. We recognise that in both those situations, under either of them, exclusion of evidence would have to be accompanied by a direction to the jury to disregard the evidence that Dr Evans has already given. We submit that can be done. There are 3 ways, and we summarise them at our paragraph 6, in which we say that Dr Evans has stepped well outside the boundaries of expert evidence, but in putting these before the court, we say, as we say elsewhere in our argument, that we are trying to apply a categorization to what is in fact the generality of his evidence and its totality. But trying to apply a categorization for ease of analysis, we say that he has constructed theories that are designed to support allegations on the indictment rather than to form and present independent opinion on the basis of facts. So what he's saying here is he's not giving impartial evidence, he's trying to prosecute. He is secondly given evidence in a manner that is improperly subjective, emotive, dogmatic and biased. And finally, but closely connected to that and the first point, he has acted as an investigator or as someone who has directed this investigation. And we add, as I will develop when we come to this, that has or is part of a whole in which the lack of objectivity is plain and he has stepped outside of any proper boundary of being an objective, independent, expert witness. So I would think that is very clear. These are matters, my lord, that have been put to Dr. Evans variously in the course of his evidence in the trial, and Mr. Justice Goss is already trying to hide behind this immediately, and vigorously. But we submit quite properly. Mr. Justice Goss agrees, and I'll deal with that in due course, but lest there be any doubt, his evidence has been extraordinary. I don't think anyone could reasonably disagree with that. Anybody watching it, reading it, or listening to it would be astonished that an expert like that behaves as he does. Again, I don't think anyone can disagree with that. What Mr. Myers didn't know was the way that Evans was going to behave after the trial had been completed, which is possibly even more astonishing. I will deal with the personal criticism made in the course of the prosecution response in due course, but this should not be, we respectfully submit, an exercise in sanitising the behaviour of someone who stepped far outside the proper bounds of expert evidence, both in his conduct generally in the investigation and in his conduct in evidence. So yes, if there has been a vigorous challenge, there has had to be with a witness like this. And Mr. Justice Goss says, I wasn't being critical of you, Mr. Myers. Well, my lord, I was simply indicating that at each stage you were challenging and did quite very properly challenge, so it wasn't just a superficial challenge. No, it wasn't, my lord. I won't take that as a criticism in that situation. No. But when I come to deal with the prosecution response, your lordship will see why I'm attuned to that line of response to the submissions that I make. On the 9th of December, the defence set out a disclosure request setting out requests for material based upon the evidence and behaviour of Dr. Evans, and that is based upon not just material pre-trial, but importantly the way his evidence has developed and been presented in the course of the trial. We have had some disclosures and we are grateful for those. We received some more this morning to which I shall make reference. There remain requests outstanding. On the 15th of December, the defence were provided with a decision of Lord Justice Jackson in the Court of Appeal Civil Division relating to an application for permission to appeal, in which a report by Dr. Evans was submitted to the court as further evidence in support of the applicant's case. Now, of course, we're all familiar with this. This is the worthless report, of course. Your lordship has that, of course, and I've put the references in the bundle. We have also received the report to which that related. I'll turn in due course to what Dr. Evans has said about that. Your lordship has that. But it is important now just to be clear and set out what Lord Justice Jackson says in the final paragraph of his decision. We cite this at paragraph 14 of our application. He says this: finally, and of greatest concern, Dr. Evans makes no effort to provide a balanced opinion. He either knows what his professional colleagues have concluded and disregards it, or he has not taken steps to inform himself of their views. I mean, I would suggest it's the former. I think he probably has informed himself of their views, he's just disregarded them. Either approach amounts to a breach of proper professional conduct. No attempt has been made to engage with the full range of medical information or the powerful contradictory indicators. So that's very important, because we see that pattern being played out again in this case, where there is no effort made by Dr. Evans to engage with the full range of medical information. So stuff about the hospital, and of course he's ruled out all kinds of things. He seems to have completely ignored the clinical signs in these infants, or what could be described as powerful contradictory indicators. Instead, the report has the hallmarks of an exercise in working out an explanation that exculpates the applicants. It ends with tendentious and partisan expressions of opinion that are outside Dr. Evans' professional competence and have no place in a reputable expert report. Now, we've all seen that before, but when you read it out again and you see it in the cold light of day, it is an extraordinarily damning assessment of the evidence of Dr. Evans, and I would think on that basis alone that should immediately exclude him from being considered a suitable witness for any court case, let alone a court case of this consequence of magnitude. So Mr. Myers continues. That's paragraph 6 of Lord Justice Jackson's decision. We'll turn, with your lordship's leave, to what Dewi Evans says in response to that shortly. It is important I emphasise that the application made to your lordship is not made because of the receipt of that decision. The defence case concerning Dr. Evans has been mounted throughout the trial in the disclosure request submitted in advance of receiving that material. So we say that whilst the appellate decision constitutes material of grave concern in itself, it is consistent with the position of the defence to date. So he's just essentially saying what I've just said, he shows exactly the same pattern of behaviour in this trial. And then Goss says, yes, it's what you would submit is further evidence of the complaints that you make in relation to Dr. Evans' evidence. It is, my lord, and it's, this inaudible word, its purpose. But as it happens, coincidentally, we would say that it is consistent with the actual nature of those complaints. We just observe this. Just before I move to the relevant law, we are focusing in this submission on Dr. Evans' independence and impartiality. We make no concession as to his expertise, and in fact, in various ways that has been challenged and remains a live issue. Similarly, we make no concession to the independence or impartiality of Dr. Sandy Bohin, who is instructed as peer reviewer of Dr. Evans, and they remain live issues, but at this stage we're focusing upon Dr. Evans. And Goss simply says yes. To assist, my lord, we set out the law at page 4 of our application. The prosecution set out what they would add to that, or where they diverge, starting at their paragraph 3. Most significantly, Rule 19 of the Criminal Procedure Rules 2020 sets out the requirements for evidence to be admitted as expert evidence, and that's included in the defence bundle. So I won't complete this bit because it's just policy and procedure, and they're talking more policy and procedure here, so I'll go down to here. Further assistance, or rather direction, is given on, they're still talking policy and procedures. Let's go a bit further down. So this is more relevant. I'll read this out. Further assistance, or rather direction, is given under the Criminal Practice Direction 5, Evidence, Expert Evidence, which begins at page 8 of that bundle. And this states that it is dealing at 19A.1 with, in effect, the admissibility of expert evidence in criminal proceedings at common law. It sets out it would be admissible if, and there are 3 items, it is relevant to a matter in issue in the proceedings. Secondly, it is needed to provide the court with information likely to be outside the court's own knowledge and experience. And thirdly, and this is perhaps the most important aspect for this submission, the witness is competent to give that opinion. So, obviously, he's citing here the 3 factors that are established in law, under which Dr. Evans' opinion could be considered to be not admissible, essentially. And also that he would be considered not a competent expert witness. I think the fact is we know by now that he's not a competent expert witness, but he's trying to prove this to the court so that it can be understood and accepted. So then there is some references to legislation, and then Meyer says the following. Nothing at common law precludes assessment by the court of the reliability of an expert opinion by reference to substantially similar factors to those the Law Commission recommended as conditions of admissibility, and courts are encouraged actively to inquire into such factors. Then there's more listing of various legislation, and he goes on to cite this comment from the legislation: how safe the basis for opinion is when based upon inference. Secondly, whether the expert's methods follow established practice in their field. So that's critical. That's absolutely critical, because I cannot imagine any other expert in this field. Let's not quibble on the fact that he's not a neonatologist. Let's just give him the benefit of the doubt and say, okay, he's a paediatrician, he's entitled to review these notes. That's dubious in itself. But I can't imagine any consultant paediatrician or any consultant neonatologist saying, oh yes, The way Dr. Evans went about establishing these so-called diagnoses is the established practice in this field. And if you've read my book, and if you've read chapter 17, you'll see the reasons for that outlined by basically the person who founded neonatology in Canada. And that follows chapter 9, in which I extensively outlined why the diagnoses of Dr. Evans are palpably worthless. So just under that clause alone, he could easily be excluded from the court case immediately. And then thirdly, whether the hypothesis withstands scrutiny. Obviously it doesn't. Fourthly, unjustifiable assumptions. We've cited the reference to the practice direction alongside 5, a method or process that is not appropriate for a particular case, inferences or conclusions not properly reached. We say that is important, and all of these are to what we're looking at here, which I agree with. And 6, matters capable of undermining reliability or detracting from credibility or impartiality. And that's kind of the underlying or overarching aspect of this, that as we sit here today, it's clear that the evidence of Dr. Evans and the participation of Dr. Evans in the court case has seriously undermined the reliability of proceedings and absolutely detracted from their impartiality, but enormously detracted from their credibility. And of course, the court proceedings should be highly credible for a case of this importance. So then he goes on to say, that's in 19A.7, that's in the actual paragraph at the start of that section. Importantly, incorporating questions of reliability, credibility and impartiality into the exercise of considering admissibility, not just weight. This is to do with admissibility. And various factors are identified. One of them, that's at 19A.7 bracket C, is adverse judicial comment. But of course, your lordship will see in the paragraph that precedes that list, these are examples of matters. It cannot be exhaustive. But what matters for the purpose of our submission is there comes a point where matters of credibility or impartiality become matters of admissibility, not just matters of weight. The prosecution, in their paragraphs 8 and 11, seek to counter that by reference to the Law Commission report and the authority of Factortame. Of course, the Law Commission report, which is cited in these directions, was a review with proposals. These rules, under the Criminal Procedure Rules and the Criminal Practice Direction, acknowledge the report, but they set out the position, and these are the rules that govern admissibility subject to the court's assessment. Likewise, Factortame, we submit, is of relatively limited assistance here. The prosecution referred to paragraph 70 and highlight that. I will just take your lordship to that, if I may, in their bundle. So I'm just going to reflect on that passage because it's referencing numerous things that certainly I didn't know a great deal about going into this video, and probably a lot of viewers won't know a great deal about either. So I could have just skimmed over that, but I think it's important to explain these things briefly. So Factortame refers to this judicial review, Factortame Limited versus Secretary of State for Transport, a case taken against the United Kingdom government by a company of Spanish fishermen who claimed that the United Kingdom had breached European Union law. The case produced a number of significant judgments on British constitutional law and was the first time that courts held that they had power to restrain the application of an Act of Parliament pending trial and ultimately to disapply that Act when it was found to be contrary to EU law. I feel that I've mentioned this in a previous video, but it's a fairly obscure thing that I think most people wouldn't know about. It's relevant here because it contains an important appellate discussion of expert evidence and the court's role in deciding whether expert opinion is sufficiently reliable and properly founded to be admissible. And here they're referencing this was an ongoing dispute. So they're referencing something in 2002 in which the Court of Appeal discussed the duties and proper function of expert witnesses, including the need for expert evidence to be independent, objective within the expert's field of expertise, and supported by a proper evidential or scientific basis. And then this Law Commission report is this is something I knew more about, of course, because I've referenced probably several times the 2011 Law Commission report, Expert Evidence in Criminal Proceedings. Unfortunately, as we also know, this was not enacted because the Ministry of Justice declined to implement the vast majority of the recommendations. The reason that excuse me, Ben Myers is referencing it here is that it helped generate the modern rules, but the rules themselves, not the unimplemented proposals in the 2011 report, are what the judge has to apply. So I just thought I'd take the time to explain that briefly, because particularly Factortame could mean almost anything, and I think it wasn't even clear what was meant by the Law Commission report, and possibly it wasn't even clear which Law Commission report was being referenced. So then there's a bit of discussion about locating a document within a bundle, and then Myers continues. Paragraph 70 is the paragraph which reliance is placed upon. It arises out of a consideration of the relationship existing between the expert and the party planning to call the expert, and the question to which, or the extent to which, that might affect admissibility of opinion. What the court said at paragraph 70 was, this passage seems to us to be applying to an expert witness the same test of apparent bias that would be applicable to the tribunal. I apologise at this point for how long and winding this quotation is. We do not believe that this approach is correct. It would inevitably exclude an employee from giving expert evidence on behalf of an employer. Expert evidence comes in many forms and in relation to many different types of issue. It is always desirable that an expert should have no actual or apparent interest in the outcome of proceedings in which he gives evidence, but such disinterest is not automatically a precondition to the admissibility of his evidence. So, this point here of it being always desirable that an expert should have no actual or apparent interest in the outcome of proceedings, is that something you could reasonably state with regard to Dr Dewi Evans? Where an expert has an interest of one kind or another in the outcome of the case, this fact should be made known to the court as soon as possible. The question of whether the proposed expert should be permitted to give evidence should then be determined in the course of case management. In considering that question, the judge will have to weigh the alternative choices open if the expert's evidence is excluded, having regard to the overriding objective. We submit with regard to that, first of all, in no way does that remove the question of objectivity or credibility or independence from weighing up the question of admissibility. Far from it, it leaves it firmly in that territory. Secondly, on the facts, what the court was dealing with in Factortame was a far more limited situation and criticism than what we're dealing with in this case, and we submit that it is entirely conceivable that the court may be faced with an expert whose evidence, when viewed in the round, and whose behaviour takes it into a territory that is unfair or unsafe. Of course, Factortame predates both the Law Commission report and the Criminal Procedures Rule and the Criminal Procedure Direction, which set out admissibility. It also predates the bulk of the authorities that we rely upon, which assist the courts in the approach to how an expert should undertake his or her task. We set those out in paragraphs 28 to 32. I don't propose simply to recite everything that's set out there, my lord, because it's set out in some detail, but the key points we refer to are as follows. I'll give your lordship the paragraph numbers these come from. So I apologise for going over all this legislation, but it is important, as you will see as we continue. Paragraph 29 will refer to the case of Kennedy versus Cordia Services, LLP, in which the court, the Supreme Court, identified the need to look at a number of features when assessing admissibility of expert evidence. Among those, this is at paragraph 14, item 3, is whether the witness is impartial in his or her presentation and assessment of the evidence. Of course, we know this is significant. Developing that at paragraph 48, and this is in our paragraph 30, my lord, at brackets 2 and brackets 3, the court went on to say that an expert must explain the basis of his or her evidence when it is not personal observation or sensation. Mere assertion of bare ipsi dixit, which is in effect, it's this because I say it, is worthless. Now, you could hardly have a better description of what Dr. Evans does. But, you know, there's that infamous exchange where he said a baby collapsed and died, a baby collapsed and died. But this is exactly what he does throughout the court case, and that's what he has continued to do after the court case. And the court cautioned against assertion without proof, or importantly, dogmatic expressions of opinion. What, again, could there be a better description of Dr. Evans in this court case, or more broadly? That's important because an expert is in a particular position in these courts and have a particular potency, and for the proceedings to be fair, that expert must not abuse the position that he or she is in, and that may sometimes be subtle, it may sometimes be blatant. We say in the case of Dewi Evans, it's both. The authorities of Cannings, which we cite at paragraph 31, is more than just a cautionary tale, so I'm sure you're familiar with the wrongful conviction of Cannings, which is the way the prosecution describe it. It is a most salutary warning against the dangers of an over-dogmatic approach, and the court was clear in its prescription of that. It did say at paragraph 22, dogmatising should be met with an answering challenge. It might be said from your lordship's observations that had taken place to some extent in this case, but these are matters of degree. It is not unusual to have an expert who may in the moment step outside his or her purview as an expert. It is, though, we submit, extraordinary to have one who has behaved across the breadth of the investigation and in evidence as Dr. Evans has done. In the case of Harris, my lord, which we cite at paragraph 32, there are two particular observations from paragraph 271 that we cite at page 7. They are particularly pertinent. First, expert evidence presented to the court should be and be seen to be the independent product of the expert, uninfluenced as to formal content by the exigencies of litigation. Of course, one of the challenges for me in making this submission, a logistical challenge, is these matters being held in mind as one comes to assess the points that we come to later on as illustrations of this. But time and time again we submit Dr. Evans has stepped well outside these. So now Ben Mice is going to get into some of these specific examples, and he's going to start to demolish Dr. Evans and his conduct and evidence that he has submitted to the court. But before we go into that, I want to reflect on what we've heard so far. The important thing, above all else, I'm not going to summarise everything because I'll summarise at the end. Everyone that is familiar with this court case, everyone that is familiar with Dr. Evans, will be aware that so much of what we've just heard perfectly describes exactly what he did in court, and also so many things that he did in court and so many things that he's done since, and so many things that he simply does or seemingly does as a matter of fact, are absolutely defined in those regulations. I'm sure as you're hearing them, you're thinking, how can he not be thrown out of the court case? Based on the worthless report, based on the fact that he's not a suitable expert, based on the fact that he's retired, based on the fact that he's not a neonatologist, and based on the fact that his evidence clearly tramples all over these regulations. That's before we even go into these specific examples. So now Myers moves on to speak about the specific infants, and he begins by saying the following. For example, his evidence on child C, where out of nowhere he proposed air being forced down the nasogastric tube. I'll come to this. And when pressed on that, for which there was no evidence that he could cite, he reacts by then positing that cause of death could have been air embolus. That came out of nowhere, unsupported by anything, never formed part of the prosecution case. That's a very clear example, when one puts this into the mix with all the other material, of an expert providing opinion, first of all in a partisan and biased fashion, but also influenced by the exigencies of the litigation, which is consistent with aspects of the criticism of Lord Justice Jackson. So I guess the exigencies of the litigation is a kind of rather complex way of saying he just bats for one team. That's basically what it means. The second matter from Harris that we refer to is that an expert witness should provide independent assistance to the court by way of objective and unbiased opinion in relation to matters within his expertise, and should never assume the role of advocate. So both of those, Ben Mize is going to continue, but both of those issues that he's just brought up, acting as a role of advocate and the child C issue, we're both fully familiar with. I don't think anyone could possibly contest that. And of course, Ben Myers didn't know what he was going to do, as I mentioned, after the court case, where he became a much bigger advocate. And we submit, I'll return to this shortly, that if one considers what your lordship has seen in the course of this case and heard, looks at the transcripts perhaps to reacquaint oneself with the type of evidence that was given, there most definitely has been advocacy performed by Dr. Evans. It might be said there's been advocacy performed by me, but that's less surprising since I'm an advocate. So there are the principles against which admissibility in my submission has to be considered. The case of Bates, which is cited in Archibald in fact, and I refer to it at paragraph 36 of our submission, suggests that the discrediting of a witness goes to weight rather than admissibility. I've dealt with this. It is of limited application. It's a judicial review relating to a search warrant where one of the claimants was a forensic examiner of computers and his status as that was in issue. That is what the court was dealing with. It is a very, very far cry from the extent and detail that we're dealing with in this case, which is why we say that whilst there may be cases where credibility does not step into the area of admissibility, it may, and that's clear from the criminal practice direction and from the authorities. So just to mention here, the prosecution is probably claiming, yes, it's an issue, it's maybe what the defence is saying is true or fair, but that's a matter of weight, in which case the jury will decide, as opposed to admissibility, in which case the evidence will be thrown out of court. We say it's important in this case because at our paragraph 35, there isn't just one distinct issue of credibility here. There are very many different issues and examples, far too many to put into this one argument. We say it's important in this case because at our paragraph 35, there isn't just one distinct issue of credibility here. There are very many different issues and examples, far too many to put into this one argument. There is criticism made by the prosecution that some of the sections we've identified should be further particularised, but it's possible for all who have been involved to refresh ourselves from those parts of the transcript and to recall the flow of the evidence. To try to particularise every comment or shot delivered by Dr. Evans would be very difficult to do because there are so many. They are repeated, they are spread across the allegations, and importantly in this case, they are, we submit, fundamental to the character of his evidence, and many of them go to the way in which he has reached his opinions and expressed them. That, my lord, is what we say about the background and the law relating to this. We turn from that to the examples of the evidence and conduct of Dr. Evans, and they are merely examples. It is necessary for me to deal with some of the matters raised by the prosecution in their response. Paragraph 13 of the prosecution response is critical of what they say is defence emphasis of some of this material, that it exaggerates alleged shortcomings or says the emphasis may be wrong, as happens when a proofread document is produced at home in a calm atmosphere. I don't recognise what that applies to. Any one of these criticisms is a serious concern. The evidence we submit from Dr. Evans has been emotive, evasive, obstructive and designed to argue an opinion and a position. And if you've seen the previous videos, and there'll be more in the future, in which I go over the court transcripts in which Dr. Evans has been cross-examined, you'll see that that is a very fair description and a very accurate description. I'm going to turn to the first example in a moment, but before doing that, a general point is this. The prosecution response is in their paragraph 3, in fact, is to seek to judge Dr. Evans' evidence against other evidence in the case. It's at paragraph 3 on page 1 of their report. It's a general point that bears dealing with before I turn to the examples. In the second part of that paragraph, starting on that page, your lordship will see that the prosecution seek to gain some support for Dr. Evans' position by reference to other evidence in the case and the overall strength of the case. And in particular, they pick out what I've described as the insulin charges. We observe respectfully an approach like that is misconceived because two entirely separate issues are being conflated. On the one hand, there is the question of the strength of the evidence in this case, or the weakness, and the prosecution have cited a variety of areas where they would maintain there is evidence that is supportive or strongly supportive of their case. That's one issue. The issue of the objectivity or independence of an expert as to whether their opinion can be admissible is an entirely different issue. If an expert is biased or not objective or partisan, or acting as an investigator in various respects rather than a pure expert, that affects admissibility irrespective of the strength of the evidence elsewhere. If that wasn't the case, then an expert could behave in any way that he or she saw fit, stepping well outside the bounds of admissibility, and that could be met with the argument, well, it's a very strong case, it doesn't matter, which is really what that reduces to, in the sense that the prosecution seek to shore up his credibility, in effect by saying, well, look at how this might match other parts of the evidence. But they are two different issues. They presuppose that evidence is strong. They do not deal with the situation of what happens when an expert like Dr. Evans starts hypothesizing where evidence may not be as clear. So that was quite a long section where Myers talks about some of the technical aspects of the case legally. And essentially what he's saying is another circular argument from the prosecution. They're saying the evidence is strong, so it doesn't matter about Dr. Evans, but of course Dr. Evans is the person who's providing the evidence. Without Dr. Evans, there is no case. For example, returning to the incidence of baby C, it's all well and good if Dr. Evans has things to say about insulin that may or may not be clear on the evidence, putting aside the question of who would be responsible if that happened. But to have an expert who creates opinions from an impartial basis becomes increasingly dangerous when the evidence may not be so clear, or where there are more acute questions to be dealt with that engage with causation. And it isn't enough in that situation to look at the generality of the case and pick out one or two incidences where his evidence may be consistent with the prosecution theory based upon their evidence. Indeed, in certain respects, the defence would say, given the criticisms we make of Dr. Evans, it's not surprising that at certain points his evidence may be consistent with the prosecution allegation. Indeed, he is the foundation of the prosecution allegation, so of course they're going to be consistent. Essentially, that's a nonsense argument. So we submit one cannot assess the admissibility of expert evidence by reference to the strength or otherwise of the prosecution case, and in any event, what's said in that paragraph presupposes a great deal about what the evidence means and what it goes to prove in most of the incidences cited. The first criticism or category that the defence raise, again emphasising it's with a degree of convenience that we do this because it's impossible to encapsulate in one sentence everything that can be said about Dr. Evans. But at page 9 of our argument, paragraph 41, we deal with the first category, which is the construction of theory to support the allegation rather than to form and present an independent opinion on the basis of facts. We've given examples. They are only examples. Your Lordship has seen the evidence. Some of them require no further explanation, some maybe a little more. We've given examples of the way in which, in the case of child A, Dr. Evans hypothesised the use of potassium chloride when there was no basis for that. And when cross-examined about it, said he did so to give the police ideas, which we submit, that may seem, we wouldn't say it's innocuous, but it may seem minor, only minor by reference to the rest of his evidence and the enormity of that. So of course, this is all fair comment. We know about the potassium chloride. We know he made this comment about giving the police ideas. We know what his modus operandi was. That's been very much established. I think, in fact, that this should be considered extremely serious, considering what else we know. So Ben Myers continues, we say, just pausing there, and I'm not going to go into this detail on everything, to have an expert who says, I've given that suggestion to give the police ideas is extraordinary. That's not the expert's role. Absolutely fair comment. I don't think anyone could possibly disagree with that. Nasal prongs being intentionally removed from child B. He also, in fact, in his report suggested smothering. Of course, to interject here, he then threw smothering into child H. Child H has just got a collapsed lung. Completely preposterous. But stepped away from that in evidence, so he just threw that into the report. As I mentioned, Ben Myers, I don't think makes reference to this, but in another case, he just threw in the noxious substance, even though that's not in his reports, and that's a headline on the BBC website. I've shown you that before. So he'd throw these things in, clearly acting as an advocate for the prosecution, and just willing, as we've seen, to, it would appear, say things that are unfounded and don't even appear in his reports, and just randomly throw them into the court case. Now, that's deeply inappropriate. It's completely wrong, and I hope one day that this is properly examined. Once Lucy's been exonerated, I hope this court case is properly examined and the conduct of Evans in the court case is examined as well. Because I think the most generous thing you can possibly say, and I'll say the most generous thing, is that it was deeply inappropriate. So Ben Myers continues. A clear example of this, which we put at our brackets 3, is in the case of child C. I will just dwell upon this for a moment because it reveals so much about this expert's evidence. Dr. Evans had produced at least 5 reports in that case and participated in the joint report. At no time did he advance any opinion as to how harm was caused to child C or a mechanism of deliberate harm, and he did not identify a cause of death. It matters not what other experts may have said in reports elsewhere, he never did. However, in evidence in chief and without prior notice, he stated death was caused by air being forced down the nasogastric tube. We've put the reference to that, should your lordship wish to remind yourself. It's the transcript for the 1st of November, page 107, line 7, but we summarise it here. Putting to one side, though, it's a big enough deal in itself. The fact that none of this complied with the rules on expert evidence, what is extraordinary is that a mechanism like that should be suggested for the first time in evidence in chief without any basis for it whatsoever or any precursor. So I don't think this requires any commentary. I think we're familiar with this, and I think this is undeniable. When he was asked in cross-examination as to the basis for this fresh theory, he could give none. This is at page 10, brackets 4, none. We submit that evidence was not properly argued, it was not objective. It was biased and was designed to come up with a theory to support the allegation rather than to reflect the known facts, and it is a blatant example of that, my lord. It's brackets 5 actually, sorry, said Mr. Myers. Don't apologise, I just wanted to be right, that's the passage and just refer to that. I referred to it as 4, brackets 4 as well, but it's across both of those. Then there's some discussion, I won't read that because it's just talking about where it was written. So let's just have a look here. Actually, no, let's have a look at what was said. This was something that Dr. Evans came up with when pressed to explain his assertion that air had been forced down the nasogastric tube. There was no evidential basis for it. It had never appeared in any of his many reports. And then it appears to be a hostile and partisan response by a witness who had nothing else to say and could not justify an opinion that had been given without notice and without supporting evidence or reasoning. My lord, that's correct. It's beyond doubt it hadn't featured in his evidence before that point. No. There is no dispute as to that. No, exactly. It's a significant matter and not something that was novel. It appears in other cases. Indeed, there are other cases. There are several. It's important to mention he's changed this in at least 4 cases, but there are other changes as well. We say it is a reaction to what's described elsewhere by Lord Justice Jackson as the exigencies of the litigation in that moment. But it became worse because when pressed in cross-examination for the evidential basis for his evidence regarding the nasogastric tube, he reacted in fact by not giving any evidence of that, but proposing suddenly that it could be air embolus that had caused death. This is at page 145 and it runs through to page 152. It's of limited assistance for me to simply read the section out, but it is of assistance, if your lordship finds it so, to refresh your mind from the way that this went, because it is, I don't want to overuse the word, quite extraordinary. So Ben Myers as well will have cross-examined and witnessed a lot of experts speaking in court, so he knows how unusual this is. He knows how poor, essentially, the conduct of Dr. Evans was during this court case. In fact, if one looks at the top of page 145, behind tab 1 in the transcript bundle, tab 1 has the evidence for the 1st of November, page 145. Having been established that this is the nasogastric tube was not something that had featured in any report, Dr. Evans, line 3 was asked, what's the evidence you rely upon for the nasogastric tube? To which he said, I'm going to leave interpretation of the autopsy to Dr. Manarides. Your lordship knows there's... So he's hiding behind Manarides, of course. Your lordship knows there's plenty of evidence elsewhere that Dr. Evans says he relies upon when dealing with this. I asked at line 7, what's the evidence? I'm not asking you to repeat Dr. Manarides' opinion. What's the evidence you rely upon to tell the jury the diaphragm was splintered? What's the evidence? Baby collapsed, died. That's not evidence. I asked, and a baby may collapse for any number of reasons. What's the evidence that supports your assertion made today that it is because of air going down the nasogastric tube? Baby collapsed and died. Do you rely upon one image of that? Because, of course, your lordship knows we have images elsewhere where we see air in the abdomen, and the provenance may be in dispute, but at least we have the images. This baby collapsed and died, was the answer. So again, where a criticism of a question is being repeated at times, but we submit it has been necessary, he was asked, what evidence is there that you can point to that you rely upon that indicates air has been forced down the nasogastric tube? To which we get answer, right, to answer this more clearly, then he begins to talk about differential diagnosis. That doesn't talk about evidence for the nasogastric tube. And moving down to 146 line 5, answer, this baby collapsed and died. This baby collapsed and died. And I have on the top of my list, and this is the result of what we have discussed, is there a differential diagnosis? The answer to that is yes. This baby could have collapsed as a result of air being injected in his circulation intravenously. Question, I beg your pardon, can you repeat that? You asked me and I'm going to answer, all right, let me finish please. And he went on to develop that. Not evidence of anything to do with the nasogastric tube, not dealt with in the prosecution response, in fact, this bit of what Dr. Evans did. Out of nowhere, very unfair, not at all objective, very partisan, we say, unsubstantiated by any evidence, and directly against the type of evidence that should be given as described in the authorities. And we submit it is a hostile and partisan response by a witness who had nothing else to say and could not justify an opinion he had just given without notice and without supporting evidence. Impossible to add anything to that, impossible to disagree. At our bracket 6, we refer to the case of child D, and Dr. Evans was asked to explain, given the air embolus theory, that in general it is fatal, how she was resuscitated twice, but on the third occasion it was fatal. Dr. Evans gave a lengthy answer, in effect concluding by saying that it was right because that was his view, which we submit is a good illustration of what was said about Ipsi Dixit. That is at page 147 behind tab 2, my lord. The question began at line 11 on page 147, where in effect he was being asked how is it there are two occasions when she deteriorated and there was no death, but there was then unsuccessful resuscitation on the third. He gives an account about volumes of air given and the rate at which it is given. The prosecution say that's his answer to a question that I asked. That's right. There's nothing to support that. It's just the answer that he gave. The reason we cite it is, having just said that, if we go over to the page to 148, having said it just depends upon how much air she got and how it went into her circulation, at line 8 on page 148, he concludes by saying, answer the next time, as I keep saying, the air that she suffered that was infused into her circulation was sufficient to kill her. That's it, okay? That's my medical opinion, Mr. Myers, right. Again, taken on its own, that reference to other matters or the generality of his evidence, that might seem to be some way from any complaint about admissibility. We recognise that. It's just one example of many things that he has said. We cannot possibly put down every time he said things like that in this submission, but it goes on and on. So child D, just to reiterate, is the case where the infant very obviously died of pneumonia, respiratory distress and so forth. And there's this controversy over the antibiotics not being administered, and Dr. Evans made this claim, oh yeah, I cited that, but we went over that previously, and he in fact never volunteered that information in court and downplayed it. And that was when Shuley said to him, can you give examples of where you criticised care on the unit? That was the only one they could cite, and even that one's not legitimate. So we'll continue with Ben Myers. With regard to child G, so this is a particularly preposterous case, he concludes that he's very happy with his opinion, very satisfied when there's a similar line of questioning. The prosecution are critical of this, and they talk about the length of the questioning and about the pitch of the questioning. While the court has the transcripts and has seen the evidence, I submit, because it relates to me, that there has been terrific restraint shown with a witness who has been at times rude and very often obfuscating in his evidence and advancing arguments that go way beyond the questions that he has been asked. When it is said that in the case of child G, he concludes by saying he's very happy with his opinion, very satisfied with it, and the prosecution say in their response that that was at the end of 18 pages of questioning. Yes, it's at the end of a lengthy section, but it's 18 pages long because that's dealing with the issue of what's in child G's stomach, and some of that is reacquainting Dr. Evans with the evidence on which it is based. It's necessary because that's the evidence that was key to what he was dealing with. It's not 18 pages of repetition. So we've been over that extraordinary section in which they're discussing the supposed milk overfeeding, which is just preposterous. The whole thing is just utter nonsense. Everyone knows that it's nonsense. I wonder if deep down Dr. Evans knows this nonsense. If he's standing by it, that makes him look, I would say, more ridiculous. He'd look better if he just said, yeah, it's nonsense. Sorry, I got that wrong. That would actually make him look better at this point. So we're going to move on to child E, finally. And here, this is the gastrointestinal bleeding case. Very obvious gastrointestinal bleed. Everyone that I've spoken to believes that's the case. There's absolutely no evidence the prosecution case is complete rubbish. So Ben Myers says, finally, again, as an example, it relates to child E. My lord, this is at bracket 7 on our page 11. Your lordship will recall, sadly, tragically, in the case of count 5, we deal with child E who died after a profuse gastrointestinal hemorrhage. In his third report, Dr. Evans has suggested that maybe the bleed had been caused by the thrust of a nasogastric tube. This is an expert who has emphasised in various ways and places his 30 years of experience. Nobody seriously suggests that the thrust of a nasogastric tube can have done this, and in fact, that unrealistic suggestion was abandoned by him in due course, but it is significant. This is something not just in his evidence, but that was in his reports. But then, having abandoned that, Dr. Evans produced a report on the 13th of September 2022 in which he had considered whether injury to child E could have been caused by the use of an introducer, which is a stiff but flexible wire used for intubation. What he said, and we take directly from his statement at page 5400, and this was put to him in cross-examination, was as follows. And of course, this must be measured against the guidance in the appellate authorities and the criminal practice direction. I have not seen any statement noting the presence of an introducer, therefore my opinion regarding a potential cause of his trauma must remain speculative. I believe it is reasonable to contemplate the possibility. If a member of staff recalls that a redundant introducer was present around at the time of child E's hemorrhage, I believe it is an option that is worth exploring. We submit not only is that in a number of ways objectionable, it is reliant on speculation. Indeed, Dr. Evans says that it's speculation. It's suggestions to explore possibilities for which there's no basis whatsoever. Now, I don't think he's going to bring up child O in this particular section, but of course, Lucy Letby striking the infant is another so-called possibility for which there is no evidence, no basis, no foundation whatsoever. Not only is that objectionable in itself, but it is consistent with Dr. Evans' inappropriate approach to his role as an expert and the evidence in general. This chimes with what we say elsewhere when we look at how he's become involved as either an investigator or a directing mind of the investigation, which places him automatically in a very partisan position. And however investigators may have to conduct their duties, it comes from a witness who said he suggested potassium chloride to give the police ideas and has run with various theories, dispensing with them and adopting new ones, we say, in the consequence of the exigencies of the litigation, all of which I think, again, is completely undeniable. But plainly here, my lord, it does speak for itself and it amounts to looking for a way of furthering an investigation which currently has hit a blank because there was no post-mortem and the nasogastric tube theory doesn't bear scrutiny, furthering the investigation with speculative inquiries that we submit no impartial expert acting objectively should consider. And again, I think it's impossible to disagree with that. Those are just examples of the construction of allegations. So at this point, we're just over a quarter into this explanation by Ben Myers. As you can see, it's already been a pretty ferocious annihilation of Dr. Evans, but I'm going to look at the remainder in future videos. But at this point, I'd like to just go back and reflect about what we've heard in this first section. So there was a lot of information included, even just in that first quarter of the submission. But I just want to try to summarise it as succinctly as possible. Effectively taken together, these examples form the basis of a much broader defence criticism of Dr. Dewi Evans, not simply that individual conclusions were open to challenge, but that his entire approach to the case repeatedly departed from the standards expected of an independent expert witness. Across children A, B, C, D, E and G, Myers identified a recurring pattern in which speculative mechanisms were proposed without a clear evidential foundation. theories were introduced, modified or abandoned as difficulties arose, and Evans at time appeared to move beyond evaluating the evidence into actively developing lines of inquiry for the police and prosecution. The child C evidence was perhaps the clearest illustration, with a new nasogastric tube air theory appearing for the first time in oral evidence, and an alternative air embolism explanation emerging when that theory was challenged. But similar concerns arose over potassium chloride in child A, supposed intentional interference in child B, unsupported assumptions about the volume of air in child D, the changing trauma mechanisms in child E, and the dogmatic defense of the preposterous milk feeding theory in child G. Myers' ultimate submission was therefore that the problem was cumulative and fundamental. Evans had ceased to function as a detached medical expert and had instead become an advocate and investigative participant whose opinions were repeatedly shaped around sustaining allegations of deliberate harm. On that basis, the defence rightly argued that the issue went beyond the weight a jury should attach to his evidence and instead raised the much more serious question of whether his evidence was sufficiently independent, objective and reliable to have been admitted at all. It is increasingly clear from what we know about both Evans and this court case that Goss should have excluded both the retired paediatrician and his evidence from the entire court case rather than Goss hiding behind the jury. In future videos we will continue to examine this key defence argument in more detail.